Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. On behalf of our entire Wisconsin Facets staff, I'd like to thank you for joining us today. Our webinar today is entitled Educational Services for Students with IEPs in Foster Care. Our presenters today are Julie Inciti and Eva Shaw. Julie is the School Social Work Consultant at the Department of Public Instruction. Her areas of focus include best practices in professional ethics and boundaries, supporting students involved with child welfare, attendance, truancy, pupil records, comprehensive school mental health systems, trauma-sensitive schools, and reducing and responding to sexual violence in schools. Eva is an educational consultant on the special education team at the DPI. Her role focuses on supports for students with IEPs with social and emotional and neurodiverse needs. She has worked in the field of special education for over 25 years and has had the privilege to serve children, families, and schools in a variety of roles as a special education teacher, diagnostician, and program support teacher, as well as a PBS external coach, NVCI instructor, and special education supervisor. It gives me great pleasure today to introduce to you Julie and Eva. Ladies?
Thank you, Bonnie. I'm Eva Shaw, and I'm going to kick us off today, and Julie and I are going to take turns presenting all of the information that we have regarding educational services for students with IEPs in foster care. And our objectives for today, after our little short time together, we only have an hour, but after our time together, hopefully you'll have an understanding of special education referral and IEP team participation for students in foster care. You'll understand access and disclosure rights to pupil records, and then responsibilities of school districts in the provision of services. We have a lot of resources that you can, there's a link in the PowerPoint, and I want to put this up front as well because we're going to be going over a lot of information. So if you feel like you've missed anything, most of what we talk about today can be found in this resource list. There's information on special education resources, information on educational stability for students in out-of-home care, and much more found in this resource list. So please know that that's available to you, linked in the PowerPoint. And then just to get us started, I just always have loved this quote, and I feel like it's really appropriate for our conversation today. It does take a village to raise a child, and really all of us, we all are the village. And as we look at the village of our supports, it's interesting to know that there's approximately 7,000 children in Wisconsin who are in out-of-home care, and this data comes from December 31st, 2020. And of those students, approximately 20% of them are reported to have a clinical diagnosed disability, which is thought to be an underestimate. And that clinical diagnosis includes things like physical disabilities, visual or hearing impairments, emotional dysregulation, learning disabilities, or other medically diagnosed conditions that require special care. Now, when we think about special education, an outside medical or clinical diagnosis is not the same as special education. And having an outside medical or clinical diagnosis is not enough evidence to identify special education eligibility. So to be eligible for special education services, a child or student must be identified as a child with a disability under state and federal special education law. A student with a disability is one who requires specially designed instruction as a result of meeting the criteria for at least one of the identified disability categories under state and federal special education law. So a child may have a medical diagnosis, and the IEP team, when they're doing a special education evaluation, would look at that medical diagnosis. But like I said earlier, that's not enough to identify special education needs. special education needs, a child would have to meet criteria for at least one of the special education categories, like a specific learning disability, an emotional behavioral disability, other health impaired, blind, visually impaired. There are 11 special education disability categories in which a child has to be identified, and then also identify that they require special education services. And just a couple of key ideas, key terms as we start talking about the IEP process, or briefly talk about the IEP process. Like in any field, special education has a wealth of acronyms, and I wanted to put these up front in case I use them without explaining them as we go along in our conversation today. So just some key terms to be aware of. FAPE is free appropriate public education, and FAPE is a real important legal right to be aware of. It requires schools and districts to provide special education services to meet the unique needs of students, and it includes completing the special education evaluation process to determine if there are special education needs. So FAPE is a real important legal right to be aware of. IDEA is the National Special Education Law. It gives rights and protections to students with IEPs, birth through high school graduation or the age of 21. The IEP is the Individualized Education Plan or program, and that is the written legal document that lays out the services and supports for students with disabilities. And in Wisconsin, LEA, that's the local education agency, and LEA is school districts. The Department of Health and Services, Department of Corrections, and other non-district charter schools are considered LEAs. So LEA is a school district, or there may be an LEA representative on the IEP team. So to get started, if someone suspects that a child has special education needs, to start the special education process, a referral has to be made, and anyone can make that referral. That referral should outline the concerns or reasons someone believes a student has a disability and requires special education services. And any person who reasonably believes that a child is a child with a disability can refer the child to that LEA, to that school district. And some people are required to make referrals. School staff are required to make a referral if they suspect a child has a disability. A physician, a nurse, a social worker, they're all required to make that referral if they think that the child has a disability. And if someone other than a parent, the parent makes that referral, the parent has to be informed that a referral will be submitted. They don't have to give permission for the referral to be submitted, but they do have to be informed that someone suspects a disability and is making that referral. Once that referral is made, it starts a timeline for the special education process. And the first step is for schools or districts to form a team, which includes the parent. And they look at what they know about the student and what they need to know to learn whether or not the child has a disability and requires special education services. So at the very start of the process, they make an evaluation plan and they determine if any assessments are needed to be completed to make a determination. And part of the information that they look at the beginning of the referral is if there is a medical diagnosis, if that's known, and what else they need to know to make that special education determination. So once they have that referral, the LEA has to obtain informed written consent from the child's parent before conducting any assessments. They have to get consent to conduct that initial evaluation, and the permission is for the evaluation only. It's not, there's 2 times that permission is needed. Permission is needed for the evaluation for additional assessments, and then later, after the evaluation, permission is needed for the child to receive any special education services that the IEP team determines are needed. And did I hear someone? I thought I heard someone ask a question. No? Okay.
No questions at this time.
Okay, sorry. I thought I heard Someone asked something. All right. So when we say that the parent has to give consent for conducting any assessments, for completing that special education evaluation, there are many different definitions of who is a parent. There's definitions under IDEA. There's definitions under the Juvenile Justice Code. There's definitions under the Wisconsin State Statute Special Education Law, which says that a parent is the parent. The parent is the parent. If the court order says otherwise, then you have to follow that order. And if the parent does not want to be the parent or cannot, and attempts were made, there may be a person acting as a parent or a surrogate parent determined. And I'm going to go over some of those in the next slides. So the person acting as a parent, such as a relative of the child or another individual allowed to act as a parent of the child by the child's biological or adoptive parents or guardian. This could include a grandparent, a neighbor, a friend, or any private individual caring for the child with permission from the parent. A surrogate parent can be appointed. A parent could also be that surrogate parent who is appointed to protect the rights of the child with a disability. The surrogate parent cannot be an employee of the LEA or the district, cannot be an employee of DPI or any CISA or other agency that is involved in the local, in the education or care of that child. The surrogate parent could be or should be appointed by the LEA whenever the child's parents are not known. The local education agency cannot, after reasonable efforts, locate the child's parent, or the child is a ward of the state. A foster parent could be the parent for special education purposes if the parental rights and responsibility to make educational decisions has been extinguished by a termination of parental rights or by transfer of guardianship or legal custody or court order, and if the foster parent has an ongoing long-term parental relationship, is willing to make education decisions, and has no interests that conflict with the interests of the child. And this is all found in Wisconsin state statutes, which is also on this slide if you're interested in the complete state statute. And so participation in the IEP process, the people who are able to participate are, of course, the parents, foster parents with authorization to access pupil records, child welfare professionals if the parent approves, and then the parent can bring other people with special knowledge of the child. So there are legal requirements who must participate in that IEP process. There has to be the parent or these other people listed on this slide. The student should be included if the student is old enough to participate and they feel it's appropriate for that child. There has to be a regular education teacher, a special education teacher in this IEP process, that LEA representative, the principal or a designee, and related service providers like occupational therapists, speech language pathologists, and additional school personnel. And then this team is collecting all that information, and they sit down together to make decisions on whether or not the child has special education needs. And like it says at the bottom of the slide, parents can bring anyone they would like to the IEP, and foster parents can attend if the parent gives them permission to attend, or the school district determines that the foster parent is a parent under that Wisconsin state statute. And then schools are encouraged to involve both parents and foster parents whenever appropriate, so that we can make the best decisions for that child. And now we're going to move into Julie with some pupil records information.
Yeah, and thanks, Eva. That's all really great information relating to IEPs and who can be involved and who's a parent. I will pause if there's any questions related to IEPs, the process, referrals, who's a parent, because then we're going to move into confidentiality and disclosure and access of pupil records. So it's a little bit of a shift in topic. So while you're thinking about IEPs and participation and the general process, please feel free to add a question to the chat right now if something's coming up for you.
We don't have any questions at this time, Julie.
All right. Okay, well, you can continue to think about those and put them in if something does come up. So when we're thinking about pupil records, I do want to point out that I'm not providing legal guidance today. So as you'll see, DPI actually does not have legal authority to enforce pupil records law. And so therefore we make sure districts know that they need to be working with their local attorney to help with interpretation of statute. But we do provide some different materials for school districts and for parents and others to help understand the basics and ins and outs of pupil records law. If there is a complaint, so let's say your school district has done something that you believe is in violation of pupil records law, then the really great place to start is with the school itself and with the school staff. These laws are very complex and it's difficult for school staff to really make sure they're looking at all of the different considerations related to disclosure and access rights. And so often the best place to get these issues resolved is just right there at the building level with the staff who you believe maybe did a disclosure of pupil records without authorization, and then certainly with the principal. So each school would have somebody appointed as the records custodian who is in charge of maintaining that confidentiality of pupil records, and is often the school principal. So that's a great place to start and to work with. However, if you don't get the resolution that you're looking for or a positive working relationship going with the principal, you can always move on to the director level at the school district, like a student service director or a director of pupil services are great folks who know a lot about pupil records and can help direct you and try to help remediate the issue there. And then still, if you're not finding the best resolution, you could file a written complaint with the school board. So sending an email to the school board president, maybe CCing the superintendent, and hopefully the school board will look into their policies and procedures around pupil records. Now, if you, in addition to that or separately from it, you can also file a complaint with the federal government related to FERPA violations. When school districts, they have to comply with both the federal law of FERPA as well as the state laws. But if you do feel like there was a violation against FERPA specifically, then you can file a complaint. And to do that, you could just type into any search engine FERPA complaint. And there's a really nice web page that gives you different videos about how to file a complaint, when it's appropriate to file a complaint, what you need to include. And then it's got information for exactly how you do file a complaint like that. So as I noted before, DPI does not have authority over complaints. So really, though, there's no place to sort of complain about pupil records generally, especially for general education records at DPI. I don't have the authority to investigate and to call up districts and force them to comply. However, if we're talking about special education records, then it is possible to file an IDEA complaint, and they can look at it through that process because special education records in particular are protected under IDEA, and our DPI does have the ability to investigate violations of IDEA. As I said before, pupil records laws are really complex. So you'll often find school staff and others looking like this person in the picture here, a little bit confused. So the thing to remember is that all of your school staff are not consistently trained in pupil records. So if a mistake is made, it's often just that it's a mistake. And it's great for you to have this information today so that you have the power to ask questions. You have the knowledge to say, hey, I learned in a training XYZ. Could we talk about this? Could we look into this? Can we look at your school district policy and make sure it's really following state and federal laws? Also, there's 421 different school districts, and like I said, they all might interpret statute a little bit differently depending on what their local attorney tells them to do and how their staff are actually working with the processes and procedures of pupil records. So each place you go might look a little bit different. And like I said, if it's not in the student's best interest, this is a great time to have some really good dialogue and conversation to ask questions based on your understanding. Again, those laws that schools have to follow, it's the FERPA, which is, right there as part of 99 of the Code of Federal Regulations. There's IDEA, that's special education. Pupil records statutes in Wisconsin are largely under 118, 125, but we might also have patient healthcare records maintained by a school. So we also have to look at 146.81. We also might have treatment records in school, so we're looking at Chapter 50. So there's a lot of different considerations, and we also don't want to forget the individual board policies, which also outline really specifics around pupil records. So again, there's just not like one place to go to clearly understand pupil records and what to do. So in Wisconsin, we have these different categories of pupil records. This is specific to Wisconsin. This is not in the federal law. In Wisconsin, we create these records categories. So it's important to kind of have a sense of what these are, because it determines the access rights and as well as the retention periods for records. So that's why it's helpful. So progress records are really just a select set of 6 types of records. So once you've determined that it's a pupil record, which means it's about a specific student and it's a record maintained by the school, then it's a pupil record. And so then you determine, is it a progress record? And the progress record are things like daily attendance, courses taken, grades, right? Extracurricular activities, some of the really basic information. And then you've got behavioral records. And behavioral records is different types of tests, psychological things can be included in here if it's created by a school staff member, behavior and discipline. And it has this clause in the definition that says any other record, any other pupil record that's not a progress record. So all of these other files we keep on students with personally identifiable information would often be considered a behavioral record. Special education records are often actually just subsets of behavioral records. So when you're going to statute to say, how long do I have to maintain this file, or what do I do with this file, you're thinking about these categories here, progress records or behavioral records. Then, like I said, we often might have patient healthcare records maintained by a school. So this would be like a record we're getting from a healthcare provider. Patient healthcare records can be created by healthcare providers in schools or coming from outside of the school system. And we actually have to think about those 2 records a little bit differently when it comes to transfers and disclosures. So just knowing that there's this extra set, the medical records, and it's great for a school nurse to be sort of maintaining and in control of these. School nurses know a lot about patient healthcare record, confidentiality, and retention. So the law gives only 3 instances in which pupil records may be disclosed. And that's if you have the written consent of the parent or the legal guardian, if you have a court order, or by authority of statute. And it's by authority of statute where things get a little bit more complex. You have to, like I said, again, look at all those different laws and then determine, is this an instance where there's sort of an exception to confidentiality, where it's okay for us to share this record with somebody other than the parent or guardian, or who other than with written consent of the parent or guardian. So these are the topics that I'm just going to go into a little bit more in detail next. So when we're thinking about access rights, the people who have access, like I just said, are those parents, legal guardians, and adult students, right? Once a student turns 18. Then we have our school.
Excuse me, Julie.
Yeah.
Excuse me for a minute. Before we go on, there are 2 questions that I think you might eventually be answering, but I think they were related to what happened before. So if I could share that with you, I'd appreciate it.
For sure.
Back to who is considered a parent. Just to clarify, would a foster parent be considered a parent if the child is post-TPR and in state guardianship? Or would the worker acting as the guardian rep be required to complete consents and authorization?
Yeah, this is such a good question. And there's it's not a very clear-cut answer here, and there's some nuances. I would probably just want to direct you towards a publication that we have at DPI, and it's called Frequently Asked questions related to definitions, roles, and responsibilities of parents, persons acting as the parent of a child, and surrogate parents. If you go to DPI, dpi.wi.gov, and into the search bar, you type surrogate parent, this document will come up because we don't have a lot of other search terms that pull up a resource from surrogate parent. But in here, it talks about this question about representatives of the state or child welfare departments having that ability to sort of access and sign for disclosure of pupil records in certain cases. And I would say that there's a little bit of disagreement in the field as well. So I don't want to say too much here. Eva, is there anything that you wanted to add?
No, there's nothing I want to add, Julie. Thank you. I was trying to look to see if it was included in our resource list, the link you just gave, and if it's not, we'll make sure to include it.
Okay, yeah, thank you. I thought it was, but it might not be.
And I do have another question that's along the same lines. In the case where legal custody has been assigned to a county social work or social services agency, is it still true that employees of such agencies are not viewed as the parent in any of those examples of quote parent?
That's correct. Generally correct. Yeah, and so you know, and caseworkers don't have the ability to sign written authorizations to release records as long as, so the parent has rights to records even if their children have been removed due to child abuse or neglect issues, unless a court order is specifying otherwise. We're really going to have to look at the individual court order in specific cases. And I'm going to go over sort of when caseworkers have access when a child is in their custody. And that statute has a may and not a shall, which means that school districts get to determine which records the caseworker would be able to have access to in those cases. So I will go into that a little bit later.
Okay, thank you. That's all we have right now.
Okay, yeah, these are great questions, everyone. Yeah, so school officials, and that should be determined in board policy, individuals to whom the parents grant access to written authorization to another school. If enrolled or intending to enroll in that school, then they can have access to the records, and then professionals and systems as determined by statute. So pointing out here that the definition of parent is not the same under pupil records law as it is under special education law, because the definition of parent, actually, there isn't one in pupil records law in Wisconsin. It's not specified. So in FERPA, there is some language for it, but this would be a place where DPI does not provide really specific interpretation of that statute. And so school districts understand this a little bit differently. Some school districts will use the FERPA definition, which would say that a person sort of acting as the parent of a child in certain situations could have access. And some districts take that to mean possibly a foster parent or possibly a step parent. Our guidance very historically from DPI has said that we look at this very restrictively, and some of the case law on the federal level also is going to understand that person acting as a parent for pupil record disclosure and access is really restrictive. And so, like I said, school districts are going to have different policies around this. So you'd really just be having to work with the specific district. But just knowing that statute doesn't sort of automatically give access to foster parents or to step parents. So the access rights of parents is that they would have access to all pupil records, including discipline and behavior records and special education records. That access must be without unnecessary delay. And unnecessary delay is 45 days. However, if it takes a school district 45 days to produce a record, that feels like there's maybe some challenges and barriers getting in their way. That would be an unusually long amount of time. And so we want to be working closely with school staff to figure out what's going on here. Maybe there was a miscommunication. And then special education records, again, repeats that it has to be no more than 45 days. But what I really want you to think about here is it includes this clause that if a parent wants access to these records before any meeting regarding an IEP, hearing, or resolution session, related to specialized services, then they do have to be granted that access before those events happen. So sometimes school district staff will say, oh, we'll go over those, test results at the IEP meeting, or we'll go over that record at the IEP meeting. And the parent, a lot of times that there's a reason for that. The school staff want to explain what it means or help to interpret the record. So, it's a good idea to be listening to school staff and their reasoning and to work with them in understanding. But it also might be, but just so that you know that the parent does have the right to request and to gain access to that record before the IEP meeting. So if there's a reason to do that, parents can request that. As I mentioned, adult pupils do get their access once they turn 18, so they become able to disclose their records as well as to access their records. Parents, however, under what state statute, do have the ability to continue to receive access to pupil record information unless the student puts in writing that they no longer wish their parent to have that access. And the reason there's an asterisk on this slide is because there is specific language that this adult student, this adult child of a parent, for the parents to maintain that accessibility to records after the child turns 18, they need to be a dependent for tax purposes of that parent. So school districts will often have a process or a form that 18-year-old students can fill out that says, I no longer wish my parents to have access to my records. When it comes to school staff, it is more than just school staff that have access, it's school officials, and a school district's board policy should outline and identify who is considered a school official and for what purposes. The main thing that we think about is, does this person have legitimate educational interest in the record, or do they need this information to do their job? So we train our school staff not to be just searching through the whole student database to look at any student and to just find out some curiosity question or answer that they have, right? They really need to have a reason, a professional reason to be looking up that record, and they'd be working with the student. And it is incumbent on school districts to figure out exactly their policies around school official access. School volunteers could be considered school officials in certain circumstances. SROs or mental health professionals in the community could be considered school officials for the purpose of serving on specific teams. So those are all things to look into. Thinking of course, knowing that when we're working with folks outside of the school system, it's great to have a memorandum of understanding or an MOU in place, but knowing that the MOU does not supplant the need for written authorizations or court orders related to the release of pupil records. MOUs just simply make it easier to understand the processes that each agency or system is going to follow. As I mentioned as well then, that individuals with written authorization from those parents or guardians or adult pupil would also have the access that that person's giving. Often school districts will have a form for this, and they'll often have categories specified, exactly which records did you want to have released to these people, because sometimes it might be just, oh, we only want to release the behavior records from last month, or we want to release all of the records or various parts. So this is the statute that I was talking about. It's in 118, 125 2Q, related to professionals from the child welfare world having access. So the language is that schools may disclose pupil records that are pertinent to addressing a pupil's education needs to a caseworker or other representative, and then there's specific groups listed there, that is legally responsible for the care and protection of the pupil. If the caseworker or other representative is authorized to access the pupil's case plan, and a note that they may not redisclose this information except to a person who is engaged in addressing the pupil's education needs and is authorized to receive the disclosure, such as an out-of-home care provider or foster parent, or to the court. So let me give you an example of what this can look like. I worked with a student who was physically placed with a grandma due to child abuse from the parents. The parents would not sign a written authorization for the school to release records to the grandparent, who was the physical custodian. And so the school district, I couldn't share directly with the grandparent the daily attendance, the grades, the courses, any really basic information that, of course, for us to support the student, we needed to share with the grandparent. But what I was able to do was use this statute on this slide to share the records that I thought were relevant with the caseworker who was working with this family, and the caseworker was able to redisclose those records to the grandmother. So it was an unfortunate situation, but we were able to then do better teaming because of this statute. In general, you want to try to get the parent or guardian to sign the records release of whoever is caring for the child, who's going to be involved in their daily life, so that the school district can best support the child. We're always trying to bring it back to how can we best support the needs of the student, right? And trying to get away from trying to remove any barriers to that, which could sometimes be some record sharing issues, right? I also like to always point out that the similar clause is in Chapter 48 for our child welfare professionals. So Wisconsin does allow the confidential transfer of information regarding a child in the care or legal custody of the county or a licensed child placing agency with the child's school. And that's 4878-2B. So there are instances where I have received phone calls in my position at DPI of a school social worker who says that their county is not giving them basic information that they need about a child's placement, maybe about kind of what's going to happen next with the child, if there's going to be a transfer or change in placement or of change in schools. So those, because sometimes counties staff or child welfare professionals will say, oh, well, we don't have that written authorization from the parent, so we can't share with the school. But I do want to point out that they can. Again, it's a may, so the child welfare staff get to determine exactly which records should be shared. I would advise against sharing a whole case plan with a school staff. They don't need all those details, but sharing the pertinent information. You're really realizing how important schools are and how much time kids spend in schools, and that school staff and child welfare professionals have the same goals. We're all on the same page, working towards the same vision, and that's to support our students and families. So we want to be thinking about how can we better collaborate with schools, and how can schools better collaborate with child welfare professionals.
Are you ready for a couple other questions?
Absolutely.
Okay, the first one says, are foster parents able to sign consents for IEPs?
Great question. Yeah, and Eva, I don't know if you wanted to jump in on this one, but again, it just depends if the foster parent's been identified and appointed as a surrogate parent, and the school district would need to appoint the surrogate parent.
Okay, and the next question. Oh, go ahead. Did you have something you wanted to add, Eva?
No.
Okay, and the next question is, if the parents are not available and the school chooses not to share records with the caseworker, despite the fact that the county has legal custody and placement, what is the recourse? How can those records be accessed?
Yeah, so each school district has a point of contact that is supposed to be the person to go to when there's issues like this between the two systems. ESSA, the Every Student Succeeds Act, has a requirement for educational stability that does require both the county welfare agency as well as the school district to have that point of contact. And they are supposed to be proactively working out these sort of procedural issues to make sure that these record sharing things happen nicely, that there's support, collaboration around working with students in out-of-home care, that there's collaboration around transportation and determination related to the student's school and all of that. So, and I'm going to show you a slide here in a moment that will give you the links to both on DPI's webpage. If you do type in foster care or out-of-home care, you'll get to a section that has the points of contact. That's the term, the point of contact. And there's a list of all of the school district's points of contact and their contact information. And then on the Department of Children and Families webpage, there's the points of contact for the child welfare agency who work with the schools. So that's a really great place to go to. And if you do have a school social worker, they're a great person to connect with as well, although only 33% of school districts have even one school social worker. So we know that's not always possible. Any other questions?
Yes, and there's just one follow-up question, and that says, what happens if the school refuses to appoint the foster parent as a surrogate parent?
Yeah, so I mean, somebody has to be the parent, so the school's going to have to do that, right? They're going to have to appoint somebody if they've already tried their at least 3 contacts, 3 different ways to the parent, or if there's some other reason why the parent can't be the parent. And then, I mean, if there's no parent, then there might be a procedural violation, right? There might be some due process violation, and you could be consulting with our special education team at DPI and or possibly looking into an IDEA complaint against due process.
Okay, and the only other comment that I have now, it just says, thank you for the information. It's very helpful. And that's all I have.
Okay, I just want to add, you know, Julie's mentioned the IDEA state complaint. If you go to the Wisconsin DPI webpage and just put in the search bar IDEA complaint, it'll pull up a wealth of information about how to file a complaint, what needs to be included. So if you do have those kind of concerns, that information is readily available.
Thank you. Yeah, so just a couple of points on the GALs and CASA workers. So school districts, again, don't always understand what a guardian ad litem is. So again, just more recently this school year, we put out another helpful guidance. Hopefully it's linked in your materials. And this is called Understanding Guardianships, Legal Custody, and Physical Custody for School Professionals in Wisconsin. And one of those question and answers is about, you know, what is a guardian ad litem and do they have access to pupil records, and what is a CASA and do they have access to records, as well as public defenders. And so all of those people would actually need a court order or written authorization to access pupil records. So we want to just help facilitate that sharing record agreement. And so now this is sort of a side point to records, but I thought it was important for today to understand that there are some requirements under statute of notification to schools. So if a student is first placed in out-of-home care or has a change in placement, the school district as well as the school building needs to be notified by the child welfare agency that this placement has happened. It's very helpful for schools to have the information in a timely way, as well as really basic information like, is there somebody that cannot have access to the child, right? Is there some sort of court order in place where you, like, the school district should definitely not release this child to their parent or something? You know, some other information, and I'm going to go over the educational passport here in a moment. So, but just noting that school districts do need to be informed about placement and changes in placement. And then school districts also now need to be informed when there's a permanency plan review. And school districts have the opportunity now to provide written input for these that's relevant to making these educational decisions. So DPI does have a form for this to help school district staff, again, just to really guide these written statements, give them some legal reminders about what can and should be and shouldn't be included, and to really keep the focus on what would be helpful for the court in making these decisions around permanency. You know, just some basic information here that providing the input by the school staff is optional. The court must receive any input 10 days before the hearing date, and schools often do have that valuable information, but school staff really need training. That we really encourage districts to be talking to their staff about this. Every once in a while we'll hear about a rogue staff who, you know, knows about their, like, gets notified that they could provide a statement and their statement is very biased or judgmental, as opposed to providing the really clear, specific professional information. So it's important for school staff to know what's going on here. All right, and so here is the educational passport that I mentioned. This is a tool that child welfare professionals have in their data system called eWSAQuis. This is something that if they go to their main page, they can scroll down and then click on a button for the education passport. And this is a tool, and it populates out of it. Like, they don't have to type all of this in necessarily. It does pre-populate from their database. And this can be handed to a school when a child first is placed in out-of-home care or has a change in placement. And it's really great if these can be done sort of as quickly as possible for the school district to have the information. Again, it's information that can be shared under those statutes that I already gave you without even that written authorization from a parent. And it's just the most basic helpful stuff. You know, do you happen to know if this child has an IEP or a disability? Do they have some activations, like maybe like something related to trauma? And it'd be really good for the school staff to know, like, hey, if there's a fire alarm, this child's going to be really activated by that loud noise. And if it happens on this very first day they're in school, you know, let's think about how we're going to help the child cope, or how to deal with that. So some of those basic things, as well as just who is going to pick the kid up from school, what are their names, what is their phone number, who does not have access to the child, all these basic things. So this is in the education passport. Some counties and school districts are using these with every single kid. They have a process in place. It's happening really smoothly. And there are other school district counties who aren't really that aware of these passport tools, or just aren't using them. So if you're a parent or an advocate for a child, you can really encourage your systems to look into using these tools. And this is where I had already mentioned about those points of contact. Under ESSA and the Educational Stability Federal Law, there is, like I said, that other information that requires these two systems to be working together proactively, regularly, trying to solve barriers to any issues that are coming up relating to supporting students in out-of-home care, and to try to help increase their rates of graduation, help with their transfer of credits when they're moving around schools, and just help them have the support that they need, and the families as well. All right, so then we're going to get into this school district responsibilities, which Eva's going to take over a little bit. So I'm just going to pause and see if there's any other questions related to pupil records more specifically.
No questions at this time, thank you.
All right, then I'm going to let Eva take it away.
Okay, so we're going to talk a little bit about responsibilities of school districts and which district is responsible. We're going to revisit that idea of FAPE. If you remember earlier, I mentioned that FAPE is an important legal right to be aware of. It requires school districts, schools and districts to provide special education services to meet the unique needs of students with IEPs. In a case where FAPE is being disputed, it's best for the child welfare professionals to remember to consult with DPI to ensure that the child welfare agency and the LEAs involved are considering all nuances and specifics involved in that student's particular case. It's not always clear in complex cases which entity has FAPE responsibility. And the DPI consultants can be really helpful to have a conversation regarding those kinds of situations because of that complexity. So if there's ever a question who's responsible, please reach out to the DPI. We have experts like Julie can help point us in the right direction, or someone on the special education team as well. And in the resource list that I shared earlier, it does have a special education contact number that you can always submit a question and someone will get back to you. So always please reach out if you have questions. We also have additional guidance about FAPE responsibility by residents. There is a guidance document that helps determine that responsibility by residents. And in cases of students in out-of-home care, FAPE responsibility is generally where the student is living, where the facility or the foster home is located. So you can see on this document, it talks about, where the student's residence is, the LEA who is responsible for FAPE, for that free appropriate public education, and as well as some additional notes and nuances that you might want to be aware of. So if they're living with a parent, if they're homeless, or like the bottom one, if they are in a hospital, jail, foster home, nursing home, or shelter care. And it talks about where the LEA is responsible for FAPE, where that facility is located. And there is the note there. Oh, you're good, Julie. And then the second, this is just more information about FAPE responsibility. Just kind of goes into, places where students may be in a residential care center like Ladd Lake or Rogers Memorial Turtle Pond Recovery Center. Again, FAPE responsibility is the LEA. For this one, FAPE responsibility is the LEA before the placement in the residential care center. But there, like a lot of things in education, special education, there are nuances and exceptions to that. And it's just important to reach out. We do have someone who is an expert on residential care centers and FAPE. And again, if you submit a question through our special education line, they will get that question and be able to answer the nuances to that particular student's situation. For transfer students, under the Every Student Succeeds Act, or ESSA, a child should remain in their school of origin unless there's been a determination that is not in the child's best interest. And there's a lot of information about that determination, the best interest determination, in the resources that I shared earlier. If a student transfers to a new district, the student must get special education services without interruption. If a child moves into that district and that district is informed that they have an IEP, of course, best is to have a copy of that IEP. And the receiving LEA, the receiving school, must implement that IEP immediately without interruption. Those services must be provided until that receiving school either adopts the IEP or holds an IEP meeting and develops a new IEP. So they have to take what they know about the student special education services and start implementing them to their best of their ability until they can write a new IEP in case the situation or the needs of the student has changed.
Yeah, and so just another note in general about all the Pupil records, they do need to be transferred within 1 working day to the school in which a child has enrolled. So school districts work on doing this and with a good process if they can, but sometimes parents or caseworkers can be helpful to advocate for records to be sent right away, or to just help get information to the next school district. Sometimes, and parents have the ability to request records themselves from the school. So it's just another avenue, because sometimes this doesn't work as smoothly as we would like it to. I also had a note on here about enrollment. So just want to have school staff thinking about who can enroll students in schools. And then just so that you're aware that state statute does not specify who may or may not enroll a child in school. So it's an obligation of resident school districts to provide that education to all resident children. And that is based on where a child is sleeping at night. And then we also have compulsory attendance laws, which require any person having control of a child to cause them to attend school. So those things are all in place and overlapping, but it really just points to the school district determining their local policies around enrollment and making sure that they're thinking ahead of time about what happens when we have a student out of home care. How are we going to handle these situations and who shows up to enroll this student, right? Because it really should be a team working together to determine where the student's going to go based on that best interest determination related to school placement. So you'd have the caseworker involved, maybe the out-of-home care provider, the parent, as well as the school staff related to enrollment. And then, of course, knowing that school districts may not require a birth certificate for enrollment. School districts have to provide various options for families to provide the proof of a student's age. And there's some information on that as well. So if your school district putting up a barrier relating to a birth certificate, they need to know that it's illegal to require only a birth certificate for that purpose. And then in general, what else can schools do? What do they do? We have a lot of schools in Wisconsin doing some amazing practices to support students and families in out-of-home care. We really advocate for some universal or promotion and prevention sort of practices that are good for all students and can especially be good for students in out-of-home care. So these are things like trauma-sensitive schools, and DPI has a whole online module system to train school staff in trauma sensitivity, as well as each of the regional centers, our CSAs, have a lead person who works on trauma-sensitive schools in their area. We have a lot of resources for infusing social and emotional learning. And so this is these skills around self-awareness and problem solving and social awareness and identity, and lots of good information there that schools can be infusing in their instruction and working with kids on. And then our culturally responsive practices, and we know a school can't truly be trauma sensitive if they're not also culturally responsive. I'm working to redress any historical harms or ongoing harms. And then it's great for helping to reduce stigma for all kids and staff if we're really teaching our staff and students about mental health literacy. This is the basics of understanding wellness and different types of mental health challenges, and then doing some instruction around stigma reduction. And DPI has some lessons to be used in classrooms for mental health literacy as well as for stigma reduction. So just some basic great practices there. Eva, any other practices you wanted to highlight?
No, not at this time.
All right. And so that is, this is our presentation in a nutshell, but we wanted to, of course, we've got a couple more minutes, provide time for questions. If there are any remaining questions when you're thinking all about special education, the process, the timeline, the referrals, the team, or sharing information and records.
Sure, I do have another question for you. Who might be responsible for enforcing compulsory school enrollment? The school district, law enforcement, someone else?
Yeah, so compulsory attendance requires that parents or adults having control of a child between the ages of 6 and 18 to attend school. There is sort of an onus on the resident school district to find kids who are in those ages and to get them enrolled in school. But also in practicality, that can be very difficult for school staff to just somehow know that there's a family in their resident area. Sometimes that's brought to their attention, and then it's really helpful if they have a school social worker who can then maybe do a home visit or check in with the family and help them to get enrolled. But the true full responsibility is on the adult having control of the child, getting them to a school. And then school district policy, in accordance with state statute, determines how they enforce truancy and the different specific procedures that they need to follow related to truancy. Hopefully that's answered the question.
Thank you for that one. And then another one is, over the years, a person has been involved in sitting at IEP meetings with both the natural parents, biological parents, and foster parents at the same time. Do you have some tips about how to make those meetings go a little bit better? Because sometimes they get a little bit out of hand.
I think the best tip is to remember to always place the child in the center of that discussion. It's not about the adults and the adults' needs. It's really about how we can best meet that child's needs and making sure that we're collaborating and coordinating services to best meet those needs of the child. And so always bringing that conversation back to what that child needs and what services the school can provide to meet those needs.
I've also seen some school staff provide at the start of meetings reminders about the roles of the team members, sort of reminding how decisions are made through the IEP process and the whole team, and then who might have some ultimate decision-making authority and ability, and some reminders about that, we're all here for the student with the same goal as supporting the student. How can we all support those goals? But sometimes those reminders about how decisions are made and each of the team members' roles in supporting the student can be helpful as well.
And this is the last comment, question. Would it be a possibility that if we needed to, may we contact you with other questions?
Absolutely, sure. And our contact information is here.
Okay, thank you. At this time, we don't have any other questions for Eva and for Julie. Do either of you have any closing comments you'd like to make at this time?
I just want to thank you for having us, and please reach out if you have additional questions.
Okay, well, thank you both so very much. I know that I learned a lot, and I'm sure that all of those people who have been on the webinar with us today have as well. This will conclude our webinar. We'd like to thank everyone for joining us today. Please be reminded that Wisconsin Facets has over 100 trainings and webinars for 2022, and please keep and take a look at our website calendar and register for any of those upcoming trainings that may be of interest to you. Also, watch for the short evaluation that will be coming your way after today's live presentation. And just to let anybody know who had written an email to me during the course of the webinar, I promise I'll answer those emails after we're done today. Again, Eva and Julie, thank you so very much for a wonderful presentation today. Bye, everybody. Thank you and have a good day.